Welcome back to Criminal Procedure CRJU 201A. Today we'll be covering inspections and regulatory searches. Today our learning objectives include knowing administrative inspections, understanding special needs searches, understanding searches and seizures at the border, understanding motor vehicle checkpoints, understanding airport screening, knowing workplace drug testing, knowing searches in high schools, understanding probation and parole in the Fourth Amendment, and knowing correctional institutions in the Fourth Amendment. Today, we shift away from traditional criminal investigations and move into a different category of Fourth Amendment analysis: administrative searches and special needs searches. These two doctrines are closely related, and many textbooks treat them together because they operate under similar principles. The most important distinction to understand at the outset is this: these searches are not primarily designed to investigate a specific crime committed by a specific suspect. Instead, they are typically conducted to promote public safety, enforce regulatory schemes, or address institutional needs. Administrative searches, or inspections, are usually carried out by government agencies rather than traditional police officers. Think of housing inspectors checking building code compliance, fire officials conducting safety inspections, or federal regulators overseeing mine safety or nuclear facilities. These inspections are aimed at ensuring compliance with regulatory standards that protect public health and welfare. When violations are found, the consequences are often civil penalties, though some statutes may include minor criminal sanctions. Because these inspections are regulatory rather than criminal in focus, the Fourth Amendment analysis looks a little bit different. Courts do not automatically require the traditional probable cause standard used in criminal cases. Instead, the reasonableness of an administrative inspection is often determined through a balancing approach. The government's interest in enforcing safety regulations is weighed against the degree of intrusion on individual privacy. In many situations, consent or a warrant supported by a relaxed form of probable cause is sufficient. There is an even broader exception for what are called highly regulated industries. Businesses operating in areas such as firearms, liquor sales, mining, or nuclear power are subject to comprehensive statutory oversight. Because participants in these industries know they are entering a heavily regulated field, courts have held that inspections may occur without individualized probable cause, or even a warrant, so long as the regulatory scheme sufficiently limits official discretion. Closely related but conceptually distinct are special needs searches. These searches also fall outside ordinary law enforcement purposes. They are not conducted to gather evidence for criminal prosecution. Instead, they serve governmental objectives that go beyond routine crime control. Special needs searches may be carried out by a wide range of actors: airport security personnel, public school officials, probation officers, or public employers. Examples include border searches, sobriety checkpoints, drug testing of certain employees, searches of students in schools, and supervision searches of probationers or parolees. Like administrative inspections, special needs searches generally do not require a warrant or traditional probable cause. Sometimes they are based on reasonable suspicion. In other situations, such as certain checkpoint programs, they may occur without any individualized suspicion at all. Again, courts rely on balancing. The question is whether the government's need, such as protecting public safety or maintaining institutional order, outweighs the privacy interests at stake. The central theme in this chapter is that administrative and special needs searches are analyzed under the Fourth Amendment's general reasonableness requirement rather than the warrant and probable cause framework that dominates criminal investigations. The Supreme Court has repeatedly concluded that insisting on traditional probable cause in these contexts would significantly hinder the government's ability to carry out their important regulatory and protective functions. As we work through the cases, let's ask ourselves, is this truly separate from ordinary law enforcement? Does the governmental objective justify relaxing the warrant requirement? And does the court strike the right balance between collective safety and individual privacy? We'll also consider a broader theoretical question. Should the law clearly separate administrative and special needs searches from criminal investigations? Or does expanding these categories risk weakening the protections the Fourth Amendment was designed to secure? That tension between flexibility for government and protection for individual liberty is what drives the entire area of constitutional law. We'll start with administrative inspections of homes and businesses. These are searches conducted not primarily by police investigating a crime, but by government agencies enforcing regulatory standards. The goal is compliance, not prosecution. Think about the range of regulatory schemes in modern society. Restaurants must follow health codes, bars and clubs must meet fire safety standards, gun dealers must maintain detailed records, factories must comply with workplace safety rules, apartment buildings must meet housing codes, immigration authorities may inspect employment records to ensure businesses are not hiring unauthorized workers. These inspections are part of the everyday regulatory state we live in. Most of these inspections are conducted by administrative officials rather than traditional police officers. Violations usually result in civil fines. However, in some situations, regulatory violations can also trigger criminal penalties. For example, improper disposal of hazardous chemicals may violate environmental regulations and also constitute a separate criminal offense. The foundational case in this area is Camara v. Municipal Court. In that case, a San Francisco ordinance allowed housing and safety inspectors to enter private residence without a warrant. Roland Camara refused entry when inspectors attempted to conduct a housing inspection without judicial authorization, and he was prosecuted. The Supreme Court held that administrative inspections of private homes are subject to the Fourth Amendment. The court rejected the idea that regulatory searches are automatically exempt from constitutional protection. Even when the government is acting for public safety rather than criminal investigation, individuals still have a right to be protected from unreasonable official entry. At the same time, the court recognized that housing inspections serve an important public purpose. Society has a strong interest in preventing fire hazards, unsafe wiring, structural defects, and other dangers. The court therefore adopted a modified probable cause standard. Instead of requiring evidence that a particular home contains a specific violation, an inspector may obtain what is sometimes called an area warrant. This type of warrant allows inspections based on neutral criteria, such as the age of buildings or a general inspection plan for a neighborhood. Consent, of course, eliminates the need for a warrant. The same principle was applied to commercial property in C versus City of Seattle. There, a warehouse owner refused entry during a routine fire code inspection. The court held that business owners, like homeowners, are entitled to Fourth Amendment protection. Inspectors may not simply decide in the field to enter private commercial property without judicial authorization. However, the probable cause standard remains flexible. The inspector need only show that the business falls within a class of properties subject to periodic inspection. The court carved out an important exception for what it calls closely regulated industries. This exception was fully articulated in New York v. Berger. In that case, police conducted a warrantless inspection of an automobile junkyard and discovered stolen vehicle parts. The court upheld the search, reasoning that auto dismantling is a heavily regulated industry with a long history of government oversight. When a business operates in a pervasively regulated field, such as liquor sales, firearms dealing, mining, or nuclear power, the owner has a reduced expectation of privacy. Warrantless inspections are permitted so long as the regulatory scheme limits official discretion and provides notice that inspections will occur during business hours and within defined boundaries. However, the court has also made clear that there are limits. In City of Los Angeles versus Patel, Los Angeles required hotels to keep detailed guest records and make them available to police on demand. Failure to comply was a criminal offense. The majority held that the ordinance was unconstitutional because it did not provide hotel owners with an opportunity for pre-compliance review before a neutral decision maker. In other words, even in a regulatory context, there must be some procedural safeguard that prevents arbitrary or harassing inspections. The court did not invalidate the requirement that hotels maintain records. It held only that police access must be subject to judicial review, such as through a subpoena or administrative warrant. Justice Scalia dissented, arguing that hotels operate in a context where criminal activity such as drug trafficking and prostitution is a real concern. In his view, surprise inspections were necessary and consistent with the closely regulated business doctrine. One additional point is important. If inspectors lawfully discover evidence of a crime in plain view during an administrative inspection, that evidence may be seized. But if the government shifts from regulatory enforcement to a full criminal investigation, officers must then comply with traditional Fourth Amendment requirements and obtain a criminal warrant based on probable cause, as emphasized in Michigan v. Clifford. The central theme in this area is balance. Courts weigh the government's interest in protecting public health and safety against the individual's privacy interest in their home or business. Administrative inspections are permitted, but they are not unlimited. The Fourth Amendment still applies, just in a more flexible form. In the next section, we will move from administrative inspections to special needs searches, where the court uses a similar balancing approach, but in other contexts such as schools, checkpoints, and probation supervision. Special needs searches do not serve the ordinary needs of law enforcement and are intended to promote the safety and welfare of individuals and of the public. They are not intended to gather evidence of a crime. The reasonableness of these searches is determined by balancing the interests of the government against the privacy rights of the individual, and these searches generally do not require a warrant or probable cause. The courts employ a two-step analysis in special needs searches. The first step is to establish that the search is directed at a special need beyond the special needs of law enforcement. In other words, the search is not being carried out to investigate a crime. The second step is to evaluate the reasonableness of the search. The court asks whether the government interest at stake outweighs the individual privacy interest. In those instances in which the probable cause or warrant requirement interferes with the government's achievement of the special need, courts have held that it is reasonable to conduct the search based on the lesser standard of reasonable suspicion or without any articulable suspicion whatsoever. Pay attention to the balancing process undertaken by the courts in considering the reasonableness of these various searches. Border searches are brief and unintrusive routine searches at the United States border that may be conducted without reasonable suspicion or probable cause. Non-routine searches require reasonable suspicion. Automobile checkpoints are another example. Automobiles may be briefly stopped at fixed checkpoints in the interest of highway safety. Airport screening of passengers is also an example. Airline passengers and their belongings and baggage may be searched without reasonable suspicion at all. Workplace drug testing is another example. Employees who are on the job during a railroad accident or whose job involves danger that pose a threat to the public may be required to submit to suspicionless drug testing. School drug testing and searches are also an example. Drug tests of certain students may be carried out in the schools without reasonable suspicion. Physical searches of students' purses and possessions do require reasonable suspicion. Probationers and parolees are a very common example. Individuals under the supervision of state authorities have a diminished expectation of privacy and generally may be searched based on reasonable suspicion. Not only this, but many times a probationer or parolee who enters into a plea agreement often waives their rights under the Fourth Amendment for searches and seizures. Prisoners are another more severe example. Prisoners lack any expectation of privacy in their cells, and their cells may be searched without reasonable suspicion. Inmates who have had contact with individuals from outside the institution may be reasonably subjected to body cavity searches as well. Border search doctrine represents one of the strongest exceptions to the Fourth Amendment's usual warrant and probable cause requirements. At the international border, the government's authority is at its height because the United States, as a sovereign nation, has the fundamental right to control who and what enters the country. This includes preventing illegal entry, stopping the smuggling of narcotics and contraband, and protecting national security. Because of these powerful interests, routine searches conducted at the border do not require a warrant, probable cause, or even reasonable suspicion. The Supreme Court emphasized in United States v. Ramsey that border searches have historically been considered reasonable simply because a person or item is entering the country. When someone crosses an international boundary, their expectation of privacy is reduced in a way that justifies broader governmental authority. The court has also recognized that the border is not limited strictly to the physical line that separates the United States from another country. In Almeida-Sanchez versus United States, the court introduced the concept of the functional equivalent of the border. This includes locations such as established checkpoints near the border or the arrival point of a nonstop international flight. However, the court made clear that this concept does have its limits. In Almeida Sanchez, Border Patrol agents conducted suspicionless searches on a highway approximately 20 miles north of the Mexico border. And the court held that such searches were unconstitutional because they were too far removed from the border itself. The concern was that allowing suspicionless stops deep within the interior would threaten the Fourth Amendment rights of lawful residents and citizens who lived within that area. The limits on roving patrols were reinforced in United States v. Bergoni-Ponce, where the court held that officers operating away from the border or its functional equivalent may stop vehicles only if they can point to specific articulable facts that create reasonable suspicion that the vehicle contains individuals who are unlawfully present. The rule that emerges is straightforward. At the border or its functional equivalent, suspicionless stops are permissible. But once officers move into the interior, reasonable suspicion is required. Even at the border, however, the court distinguishes between routine and non-routine searches. Routine searches include standard inspection of luggage, vehicles, and personal effects. These searches, although inconvenient, are not considered highly intrusive and therefore require no individualized suspicion. In United States v. Flores Montano, customs officials removed and inspected a vehicle's gas tank at the border and discovered marijuana. The Supreme Court held that this search required no reasonable suspicion because vehicle searches at the border do not significantly intrude upon personal dignity or bodily integrity, and the government's interest in preventing drug smuggling is exceptionally strong. The case illustrates how far the court is willing to allow the government to go when property rather than the human body is involved. When a search becomes more intrusive and implicates bodily privacy or dignity, the court requires a higher level of justification. In United States v. Montoya de Hernandez, customs officials detained a traveler they reasonably suspected of smuggling drugs internally by swallowing balloons filled with narcotics. The court held that detention beyond the scope of a routine customs inspection is permissible if agents have reasonable suspicion of alimentary canal smuggling. Although the detention was lengthy, the court concluded it was not unreasonable given the strong governmental interest at the border and the presence of articulable suspicion. Throughout these cases, the Supreme Court applies a balancing test. On one side is the government's compelling interest in protecting the nation's territorial integrity and preventing the entry of contraband. On the other side is the individual's interest in privacy and personal security. At the border, the balance tips heavily in favor of the government, but the court has not eliminated all constitutional protections. As searches become more invasive, particularly when they involve the human body, the individual's privacy interest grows and reasonable suspicion becomes necessary. The ongoing challenge is determining where to draw the line between routine inspection and excessive intrusion, and whether the court has struck the proper balance between national security and individual liberties. The concept of a motor vehicle checkpoint probably rings a bell from earlier in this semester. Many of you have likely driven through a motor vehicle checkpoint and wondered how it can be constitutional to be stopped when you've done nothing suspicious. The Fourth Amendment generally requires reasonable suspicion or probable cause before the police may seize someone, and a traffic stop is unquestionably a seizure. So how can suspicionless checkpoints be lawful? The starting point is Delaware v. Prowse. In that case, the Supreme Court held that officers may not randomly stop vehicles to check for licenses and registrations without reasonable suspicion. The court reasoned that discretionary spot checks would subject large numbers of innocent drivers to arbitrary seizures in order to catch a relatively small number of violators. The problem was not simply the stop itself, but the unchecked discretion given to officers in the field. The court emphasized that allowing patrol officers to decide which cars to stop, without standards, created too great a risk of arbitrary enforcement. However, the court suggested that less discretionary alternatives, such as fixed checkpoints that stop all vehicles, might pass constitutional muster. That issue had already been addressed in United States v. Martinez Fuerte. There, the Border Patrol operated a fixed immigration checkpoint approximately 60 miles north of the Mexico border. All vehicles were briefly stopped, drivers were questioned, and only a small number were referred to a secondary inspection area. The Supreme Court upheld the checkpoint. The justices balanced the intrusion on motorists against the government's interest in controlling illegal immigration. They concluded that the brief, systematic nature of the stop, combined with the importance of border enforcement, justified the absence of individualized suspicion. The court pointed to several features that reduced the intrusiveness of the checkpoint. The location was predetermined by supervisory officials rather than chosen spontaneously by officers in the field. Drivers received advance notice through signage. The stops were brief and conducted in public view. Most importantly, every vehicle was stopped according to a neutral formula, limiting officer discretion and reducing the potential for arbitrary treatment. In the court's view, these characteristics distinguish checkpoints from random spot checks condemned in Prowse. The Supreme Court later extended this reasoning beyond immigration enforcement in Michigan Department of State Police versus Sitz. In Sitz, Michigan established sobriety checkpoints designed to combat drunk driving. The court again applied a balancing test. On one side was the state's compelling interest in preventing deaths and injuries caused by intoxicated drivers. On the other side was the intrusion on motorists, which the court characterized as minimal because delays were brief and the procedures were standardized. The majority concluded that the magnitude of the drunk driving problem outweighed the slight intrusion involving the checkpoint stops. Justice Stevens dissented, arguing that the court gave insufficient weight to the individual's interest in freedom from suspicionless seizures. He questioned whether checkpoints were demonstrably more effective than traditional law enforcement methods and warned that the decision tilted too heavily in favor of governmental interests. His concern highlights an enduring tension in Fourth Amendment law. How much liberty should be sacrificed in the name of public safety? The limits of checkpoint authority became clearer in City of Indianapolis v. Edmond, which we discussed previously. Indianapolis established checkpoints primarily aimed at drug interdiction. Although officers also checked licenses and registrations, the central purpose of the program was to detect narcotics. The Supreme Court struck down the checkpoint. The court explained that it had never approved a checkpoint program whose primary purpose was general crime control. Immigration enforcement and roadway safety were viewed as special contexts involving immediate public dangers, but ordinary criminal investigation required individualized suspicion. The justices feared that permitting drug checkpoints would effectively allow law enforcement to bypass the Fourth Amendment's traditional protections. Taken together, these cases show that the constitutionality of checkpoints depends largely on their purpose. When the primary objective is border security or roadway safety, and when procedures limit officer discretion and minimize intrusion, the court has upheld suspicionless stops. When the purpose shifts to general crime detection, the requirement of individualized suspicion reasserts itself. The doctrine reflects a balancing approach in which the court weighs the government's interest against the individual's right to be free from arbitrary interference. The continuing debate is whether the court has drawn a principled line between permissible public safety checkpoints and impermissible general crime control roadblocks, or whether that distinction is too difficult to maintain in practice. In City of Indianapolis v. Edmond, 531 U.S. 32, the respondents, motorists who had been stopped at Indianapolis drug checkpoints, filed a lawsuit in federal district court alleging that the checkpoints violated the Fourth Amendment. The United States District Court for the Southern District of Indiana denied the respondents' request for a preliminary injunction and upheld the constitutionality of the checkpoint program. On appeal, the United States Court of Appeals for the Seventh Circuit reversed, holding that the checkpoints were unconstitutional. The Supreme Court granted cert and affirmed the judgment of the Court of Appeals. The case arose after the City of Indianapolis implemented a series of vehicle checkpoints in 1998 for the purpose of interdicting illegal narcotics. At each checkpoint, approximately 30 officers stopped vehicles in a predetermined, non-discretionary sequence. Drivers were informed that they were being stopped at a narcotics checkpoint and were asked to produce their license and registration. Officers also looked for signs of impairment and conducted an open view examination of the vehicle's exterior while a narcotics detection dog walked around the car. Each stop lasted approximately 2 to 3 minutes and no stop exceeded 5 minutes in total. except for those that had individualized suspicion. During the operation of the checkpoint, 1,161 vehicles were stopped and 104 arrests were made. 55 were drug-related arrests and 49 were unrelated offenses. The parties stipulated that the primary purpose of the checkpoints was drug interdiction. The issue before the court was whether a highway checkpoint program, whose primary purpose is the detection and interdiction of illegal narcotics, violates the Fourth Amendment's prohibition against unreasonable searches and seizures. Justice O'Connor, writing for the majority, began the analysis by reaffirming that a vehicle stop at a checkpoint constitutes a seizure under the Fourth Amendment. Although the use of a narcotics detection dog walking around the exterior of the vehicle did not constitute a search under prior precedent, including United States v. Place, that fact did not resolve the constitutional question. The court explained that the Fourth Amendment generally requires individualized suspicion, subject only to limited exceptions. The court had previously upheld suspicionless checkpoints in narrow circumstances, such as border checkpoints in United States v. Martinez-Fuerte, and sobriety checkpoints in Michigan Department of State Police v. Sitz. Because those programs were primarily related to border security and general roadway safety, respectively. By contrast, the Indianapolis checkpoints were designed primarily to uncover evidence of ordinary criminal wrongdoing. The court held that a checkpoint program whose primary purpose is indistinguishable from the general interest in crime control cannot be justified without individualized suspicion. While the gravity of the drug problem was acknowledged, the court emphasized that the seriousness of a social problem does not alone justify abandoning the requirement of individualized suspicion. The court therefore held that because the primary purpose of the Indianapolis checkpoint program was general crime control, the program violated the Fourth Amendment. The judgment of the Court of Appeals was affirmed. Chief Justice Rehnquist, joined by Justice Thomas and joined in part by Justice Scalia, dissented. The dissent argued that the checkpoints were constitutional under the balancing tests articulated in Brown v. Texas, because they served legitimate state interests in preventing drunk driving and checking licenses and registrations, were conducted in a standardized and neutral manner, and imposed only minimal intrusions on motorists. The dissent contended that the majority improperly introduced a primary purpose inquiry, and that subjective governmental motivation should not invalidate an otherwise reasonable and minimally intrusive seizure. Justice Thomas separately noted his doubts about the correctness of prior checkpoint decisions, but concluded that existing precedent compelled upholding the Indianapolis program. Port screening is one of the clearest examples of a special needs search. Although the Fourth Amendment typically requires reasonable suspicion or probable cause, courts have upheld suspicionless screening of airline passengers because of the extraordinary danger posed by air terrorism. The government's interest in preventing hijackings and bombings is considered so compelling that it outweighs the limited intrusion on individual privacy. In United States v. Marquez, the court emphasized the enormous potential harm that could result from weapons or explosives aboard an aircraft. As a result, procedures such as X-ray scans of luggage, metal detectors, and brief pat-downs are considered reasonable administrative searches. These screenings apply to all passengers, occur in public, and are directed specifically at detecting threats to air safety rather than uncovering ordinary criminal evidence. Courts have also rejected arguments that the government must use the least intrusive technology available. In Corbett v. Transportation Security Administration, the court held that body scanners and pat-downs are constitutionally permissible because the risk to human life and property outweighs the modest invasion of privacy. The same reasoning has been extended to other forms of public transportation. In Cassidy v. Chertoff, random pre-boarding searches of ferry passengers were upheld as reasonable measures to prevent terrorist attacks. Overall, airport screening is upheld because it serves a vital security function, is limited in scope, applies uniformly to travelers, and is not aimed at general crime control. Please take note that in your book, the cases that discuss airport screenings all occur after 2001. This is because of the events of September 11th, 2001. Prior to that, airport security and other sorts of screenings were not nearly as invasive or intrusive as they are today, and the concern for terrorism or air-based terrorist attacks was a lot lower at the time. So, before I jump into my analysis of McWade v. Kelly, I want to point something out that's important for you all to recognize. If you're looking at the caption for McWade v. Kelly, you'll notice that the caption is 460 F3D260. So why is that important? Well, that means this isn't a Supreme Court of the United States case. So this case actually comes to us out of the Second Circuit Court of Appeals, which encompasses parts of the Northeast, predominantly New York. So this case that we're going to discuss isn't actually binding on a federal level. So for example, it wouldn't control in the Seventh Circuit, which is, where I practice, and it wouldn't encompass the Sixth Circuit, which is where Kentucky is located. So just wanted to make that distinction, point that out to you guys that this might be a good case. And, it's very often that cases that come out of the Second Circuit and the Ninth Circuit work their way up to the Supreme Court. But presently, this case has not made its way up, and it won't at this juncture. This case is from 2006. But cases from the Second Circuit and the Ninth Circuit have a way of making national changes to the law and finding their way to the Supreme Court more often. While McWade v. Kelly isn't binding, it certainly is a good analysis of the special needs searches that we're discussing, so it is still worth reviewing. So without further ado, in McWade v. Kelly, the plaintiffs challenged the NYPD's post 9/11 subway container inspection program under 42 U.S.C. 1983, alleging that it violated the Fourth Amendment. After a bench trial, the district court upheld the program under the special needs doctrine, and the plaintiffs appealed. Following the 2005 London subway bombings, the NYPD began conducting random, suspicionless bag searches at selected subway stations. Riders were notified, they could decline by leaving the station, and officers followed a neutral formula every 5th or 10th passenger to search people. Searches were brief and limited to detecting explosives. The issues were whether preventing a terrorist attack constituted a special need beyond the ordinary law enforcement needs, and whether the program was reasonable under the Fourth Amendment's balancing test. The Second Circuit held that preventing a terrorist bombing of the subway system qualified as a special need, distinct from general crime control. Applying the balancing test, the court found that the government's interest in preventing catastrophic harm was compelling, the intrusion was minimal, and the program was reasonably effective as a deterrent. The court affirmed the judgment, holding the program constitutional, and there were no dissents, which is likely why this didn't go up to the Supreme Court on appeal. A unanimous verdict at the circuit court level typically means that plaintiffs or defendants, respondents, or otherwise are not going to push this all the way to the Supreme Court. Another major application of the special needs doctrine involves drug and alcohol testing of employees in safety-sensitive positions. The Supreme Court addressed the issue in Skinner v. Railway Labor Executives Association, which involved regulations adopted by the Federal Railroad Administration after a series of serious train accidents linked to substance abuse. Despite existing prohibitions on drug and alcohol use, multiple accidents had resulted in deaths, injuries, and massive property damage. The government concluded that stronger enforcement measures were necessary. The regulations required mandatory blood and urine testing of employees involved in major train accidents, even without individualized suspicion. Additional testing was permitted when there was reasonable suspicion that drug or alcohol use contributed to an accident or a rule violation. Employees who refused testing faced suspension. The Supreme Court first made clear that blood, breath, and urine tests are searches under the Fourth Amendment because they intrude upon bodily privacy and can reveal sensitive medical information. The key question, however, was whether these searches must be supported by a warrant or reasonable suspicion. Applying a balancing test, the court held that they need not be. The government's interest in protecting public safety, particularly in a heavily regulated industry where employees operate dangerous equipment, was described as compelling. At the same time, the court characterized the testing procedures as relatively limited intrusions and noted that railroad employees have a reduced expectation of privacy due to the safety sensitive nature of their work. The court also reasoned that requiring warrants would be impractical because evidence of intoxication dissipates quickly. Similarly, requiring individualized suspicion for post accident testing would undermine deterrence, since the unpredictability of accidents is part of what makes suspicionless testing effective. For these reasons, the testing program was upheld as reasonable under the Fourth Amendment. The logic of Skinner has been extended to other high risk occupations, including law enforcement officers, firefighters, airline personnel, and nuclear power plant employees. However, the court has indicated that suspicionless testing is not automatically permissible in all public employment contexts. In Chandler v. Miller, the court struck down a Georgia law requiring candidates for public office to pass a drug test. Unlike railroad workers, political candidates did not occupy safety sensitive positions, and there was no documented drug problem to justify the intrusion. The court emphasized that the special needs doctrine requires a concrete and substantial government interest, not symbolic or speculative concerns. The debate in Skinner illustrates the tension within the special needs framework. The majority viewed suspicionless testing as a necessary safeguard against catastrophic harm, while the dissent warned that normalizing bodily intrusions could erode privacy protections over time. The constitutional question ultimately turns on balance. When public safety is truly at stake, the court has been willing to permit suspicionless searches, but it has insisted that the government demonstrate a genuine and substantial need. For many years, schools operated under the doctrine of in loco parentis, exercising broad authority over students. Over time, the Supreme Court recognized that students retain constitutional rights in public schools. In Tinker v. Des Moines Independent Community School District, the court held that students may engage in non-disruptive political expression. Later, in Morris v. Frederick, the court allowed schools to restrict student speech that reasonably promotes illegal drug use, reflecting the special nature of the school environment. In New Jersey v. TLO, the court addressed student searches under the Fourth Amendment. It ruled that while students are protected from unreasonable searches, school officials do not need a warrant or probable cause. Instead, searches must be based on reasonable suspicion, balancing students' privacy interests against the school's need to maintain discipline. Applying this standard, the court upheld the search of TLO's purse. The court later refined this analysis in Safford Unified School District Number 1 versus Reading, which examined the limits of intrusive searches in schools, which we'll analyze next. In Safford Unified School District Number 1 versus Reading, Savannah Redding's mother filed suit under 42 U.S.C. in 1983 against the school district and several school officials after Savannah, a 13-year-old student, was subjected to a strip search for allegedly possessing prescription-strength ibuprofen and over-the-counter naproxen in violation of school policy. The district court granted summary judgment for the defendants, finding no Fourth Amendment violation, and a Ninth Circuit panel affirmed. Sitting en banc, however, the Ninth Circuit reversed in part, holding that the search violated the Fourth Amendment and that the assistant principal was not entitled to qualified immunity. The Supreme Court granted cert. The case arose after another student implicated Savannah in distributing pain relief pills at school. Assistant Principal Carrie Wilson searched Savannah's backpack and outer clothing based on reasonable suspicion, finding nothing. He then directed the school nurse and an administrative assistant to take Savannah to a private room where she was required to remove her outer clothing and pull out her bra and underpants, exposing her breasts and pelvic area to some degree. No pills were found. The pills at issue were prescription-strength ibuprofen and over-the-counter naproxen, neither shown to pose an immediate danger. The issue was whether the strip search violated Savannah's Fourth Amendment rights, and if so, whether the school officials were entitled to qualified immunity. Justice Souter, writing for the court, applied the school search standard from New Jersey v. TLO, which requires that school searches be reasonable in inception and reasonably related in scope to the circumstances justifying the search. The court held that while reasonable suspicion justified searching Savannah's backpack and outer clothing, the strip search was excessively intrusive in light of her age, the nature of the infraction, and the limited danger posed by the pills. There was no specific reason to believe Savannah was hiding pills in her underwear or that the drugs posed a serious threat. The degree of intrusion, therefore, did not match the level of suspicion. The court held that the strip search violated the Fourth Amendment. However, because lower courts had reached differing conclusions about how the TLO standard applied to strip searches, the law was not clearly established at that time. Accordingly, the individual school officials were entitled to qualified immunity. The court affirmed in part, reversed in part, and remanded for consideration of the school district's potential liability under Monell v. Department of Social Services. There was no dissent on the ultimate judgment regarding qualified immunity, though the justices filed separate concurring and dissenting opinions on aspects of the overall reasoning. The Supreme Court revisited student Fourth Amendment rights in Vernonia School District 47J versus Acton, which upheld a public high school's policy of random drug testing for student athletes. The policy was adopted after a sharp increase in student drug use, particularly among athletes, who were viewed as leaders of the school's drug culture. Despite educational programs and other prevention efforts, the problem persisted, and the school board approved a program requiring athletes to consent to random urinalysis as a condition of participation. Under the policy, students were tested at the beginning of the season, and a percentage were selected randomly each week. The collection procedures were designed to be minimally intrusive, and positive results led to counseling or temporary suspension from athletics rather than criminal prosecution. A student who was denied participation after refusing to consent challenged the program as an unreasonable search. The Supreme Court applied the special needs balancing test and upheld the policy. It emphasized that schools' custodial responsibilities to protect students and the particular risks drug use poses in athletics. The court also noted that students have a diminished expectation of privacy, and athletes even more so, given the regulations and physical examinations already associated with sports participation. The testing procedures were considered limited in scope, and confidentiality was maintained. Finally, the court rejected the argument that individualized reasonable suspicion was required. It reasoned that suspicion-based testing would be difficult for school officials to administer and could unfairly single out particular students. Random testing, in the court's view, served both deterrent and protective purposes without imposing a substantial privacy intrusion. In Board of Education of Independent School District number 92 of Potawatomi County versus Earls, the court asked whether this reasoning extends beyond athletes to all students participating in competitive extracurricular activities. Board of Education of Independent School District number 92 of Potawatomi County v. Earls, 536 U.S. 822, 2002. The Tecumseh, Oklahoma School District implemented a policy requiring all students in competitive extracurricular activities to submit to drug testing, including random tests, as a condition of participation. Lindsay Earls and Daniel James challenged the policy as a violation of the Fourth Amendment, arguing it lacked individualized suspicion and targeted a group without evidence of a drug problem. The court was asked to determine whether suspicionless drug testing of students participating in competitive extracurricular activities is a reasonable search under the Fourth Amendment. Ultimately, the court stated that it was. The court held that the Fourth Amendment's reasonableness inquiry balances privacy intrusion against the school's interest in preventing drug use. Students in extracurricular activities have a reduced expectation of privacy because participation is voluntary and subject to rules. Urine testing in a private stall with confidential results is minimally intrusive. The school demonstrated a legitimate interest in deterring drug use, and individualized suspicion is not required under the special needs doctrine in schools. The policy is a reasonable means to further the school's important interest in student health and safety. In her dissent, Justice Ginsburg argued that the policy was unreasonable because it targeted students least likely to do drugs, was more intrusive than necessary, and failed to focus on the group posing the greatest risk, unlike the narrowly tailored program in Vernonia School District v. Acton. In Griffin v. Wisconsin, the Supreme Court recognized the special need to search the home of a probationer without a warrant. Wisconsin probation officers searched Joseph Griffin's apartment based on an unauthenticated tip that he might possess guns and found a handgun, leading to his conviction. The court upheld the constitutionality of the search, noting that probationers are in the legal custody of the state and subject to conditions designed to ensure rehabilitation and public safety. Because probationers enjoy only a conditional liberty, searches based on reasonable suspicion are justified to detect violations promptly rather than waiting for probable cause. The court left open whether such searches are limited to probation-related purposes or can extend to ordinary criminal investigations. This issue arose in United States v. Knights, where Mark James Knights, on probation for a drug offense, had agreed to a broad search condition covering his person, residence, and property. After suspicion arose that Knights was responsible for vandalism, law enforcement conducted a warrantless search and discovered evidence of criminal activity. The Supreme Court held that Knight's diminished expectation of privacy, combined with the probation condition, justified the search based on reasonable suspicion of criminal activity. The court emphasized that this was a standard Fourth Amendment analysis rather than a special needs search. Finally, in Sampson v. California, the court extended this reasoning to parolees, holding that the government's interest in recidivism prevention and public safety outweighs a parolee's diminished privacy, making suspicionless searches reasonable. The question that remains is whether this rationale applies fully to probationers as well. Historically, prisoners were viewed as losing nearly all rights, with courts following a hands-off doctrine that left prison administrators free to establish policies without judicial review. Over time, however, courts recognized that prisoners retain some constitutional protections, even though officials must be given broad discretion to maintain security and order within correctional institutions. In Hudson v. Palmer, the Supreme Court held that the Fourth Amendment applies in prison, but that inmates have no reasonable expectation of privacy in their cells. Searches of cells are essential to prevent weapons, drugs, and escape attempts, and unrestricted access is necessary to maintain institutional security, given the risks posed by a population with a demonstrated record of criminal and often violent behavior. The court further addressed searches of prisoners' persons in Bell v. Wolfish, approving visual cavity inspections of inmates returning from contact visits, reasoning that the need to prevent contraband outweighs privacy concerns. In Florence v. Board of Chosen Freeholders, the court upheld strip searches of arrestees admitted to the general population, regardless of the severity of the offense. The court deferred to jail officials' judgment that such searches are necessary to prevent the introduction of narcotics and weapons, detect gang affiliation through tattoos, and identify medical issues among new detainees. Justice Breyer dissented, emphasizing that strip searches are a serious affront to privacy and human dignity, and should be limited to individuals arrested for drug or violence-related offenses unless there is reasonable suspicion of contraband. At the same time, the court has shown a heightened concern for protecting inmates' religious rights. In Holt v. Hobbs, it struck down an Arkansas Department of Corrections grooming policy that prohibited a half-inch beard for religious reasons, finding that the policy was not the least restrictive means of furthering the prison's interest in detecting contraband and facilitating inmate identification. The court recognized that while prison officials are experts in maintaining security and order, restrictions must still respect inmates' constitutional and religious rights, and policies that unnecessarily burden religious exercise are unconstitutional. Together, these cases illustrate the careful balance courts must maintain between security, order, and the fundamental rights of incarcerated individuals. In this chapter, we explored two categories of searches where courts have relaxed the usual requirements of probable cause and warrants, focusing on searches designed primarily to promote public welfare and safety rather than to investigate criminal activity. Administrative inspections, such as those for health, safety, and fire regulations, operate under a modified probable cause standard, as seen in Camara v. Municipal Court, which balances privacy interests with the difficulty of establishing probable cause for specific buildings. In New York v. Berger, the Supreme Court held that highly regulated industries like liquor dealers, gun dealers, mining operations, racetracks, nuclear plants, and railroads may be inspected without warrants or probable cause, provided statutory regulations clearly limit the scope of these inspections. Special needs searches address purposes beyond ordinary law enforcement, and courts assess their reasonableness by balancing government interests against the intrusiveness of the search. Factors such as whether requiring probable cause or reasonable suspicion would hinder the effectiveness of the search are considered. The Supreme Court has upheld the reasonableness of suspicionless airport screenings, workplace and school drug testing, and automobile checkpoint stops. Searches of students in schools and of probationers, however, require reasonable suspicion. Border searches illustrate the balancing test in practice. Routine inspections of luggage and persons may occur without suspicion, while more intrusive procedures like body cavity searches or involuntary x-rays require reasonable suspicion to protect individual dignity and privacy. Overall, the chapter demonstrates that the Fourth Amendment permits flexibility when public safety or welfare is at stake, with courts carefully weighing the intrusion on privacy against the societal need for safety and order. Next, I'll see you in Chapter 8.